Good morning, folks. We have a very special treat in the new chairman of the National Labor Relations Board, John Ring. John's a former colleague of mine. That's not his claim to fame, but we overlapped when I was at Morgan Lewis. John's career has been fundamentally at Morgan Lewis, where he's represented multi-employer funds and employers in multi-employer bargaining with unions. He actually comes out of the collective bargaining side of what of the Morgan Lewis practice. I believe, based on my interactions with John and based on some of the proposals that he has floated regarding the use of rulemaking in the NLRA, that Chairman Ring is going to go down as a very successful, innovative chairman and a real breath of fresh air. So I actually think this is going to be extremely positive administration for the NLRA, and I think both Democrats and Republicans in time will see it that way. So thank you, Chairman Ring, for coming, and we look forward to hearing your remarks.
Well, that's setting the expectations pretty high, so I better get with it.
I figured if we set them high and we get 75% of the way there, it's going to be enormously
Story of my life.
successful.
Story of my life. Well, thank you very much. For those of you who don't know me, I thought I'd give you a little bit of my background. I like to say I became a labor lawyer by accident, and for those of you who I've told the story to, I apologize, but I started my career, I've been at Morgan Lewis for 30 years, but I started my career at the Teamsters Union in Washington. I come from humble beginnings in Connecticut, and the way I got to college was through scholarships and financial aid. And when I got to Catholic University, I needed a job, and I looked for a job, and I found a $5 an hour file clerk job at this place called the Teamsters. At the time, I didn't really know what the Teamsters was, I have to admit. I had had some history classes and civics lessons, but I didn't really understand what I was getting into. But I needed a job, and I got a job. So I started my file clerk job, and what I was doing at the Teamsters at the time was I was filing the FBI wiretaps against the then general president of the Teamsters, Roy Williams. This is 1981. And I've told the story, for those of you who've been around in the law business for a while, we didn't have electronic filing. You got a transcript, and it had a subject in that transcript that you needed to file. Then you had a red weld with that subject matter, and you made a copy of that, and you put it into the red weld. So I had a Central States Pension Fund red weld with every transcript for that one, and I had a Jimmy the Weasel file, and a Tony the Rat file, and like I like to say, despite my excellent filing, as it goes sometimes with Teamster general presidents, Roy Williams did go to jail. And so, just by luck, the incoming general president, who was Jackie Presser at the time, his main person took over the office suite where I just happened to be sitting with my red welds in my files. And I ended up working a lot with him and with the general president and doing a lot of the work at the Teamsters kind of at a pretty high level for somebody who's pretty young. And that gave me a real opportunity to see how the unions work, how they interact within the union structure, with employers, with the government. I graduated from Catholic University and then went to law school nights, and the union at the time let me work during the day, and I went at night. For those of you who ever know anything about the Teamsters Union headquarters, they used to have a free lunch. There is no such thing as a free lunch anymore, but they They had a free lunch. They had a French chef, and the food, it was a very elaborate lunches, and that was my one meal a day. So I like to say the Teamsters and the unions put me through college and law school, and I'm very grateful for it. I learned a great deal from it. From my third year, law school, when you go nights, is 4 years. My third year, I went to Morgan Lewis as a summer associate. I had professors that said, why don't you try the management side, and a lot of the Teamster lawyers said, if you're going to go anywhere, you know, try Morgan Lewis. Went to Morgan Lewis. I was going to spend about 2 years there to pay off some of my student loans, and I ended up being there for 30 years, and I really enjoyed all my time. So after 30 years, I decided to try something different. I'm a big change guy, and so I threw my hat in the ring for this position, and I was fortunate enough to be selected. As many of you know, I just started at the board. I've been there just under 2 months. I'm just figuring it out. But as some of you know, we started at the board with amidst some controversies. In fact, the week before I started at the board, the Politico, there was a Politico article. Politico is kind of our political newsletter magazine in D.C. The article was entitled, "Dysfunction and Infighting Cripple Labor Agency." And the article went on to describe the then current state of the NLRB as, and I quote, "This is like when Yugoslavia broke up. You're fighting over things that happened 10,000 years ago. You killed my ancestors, so I'm going to kill you." So I was looking forward to starting. So I tell you, it wasn't quite that bad when I arrived. But here's what we were dealing with. The big thing was a case called Highbrand. You may know something about this. And for those of you who don't know, I'll give you a brief background on it. Highbrand was one of those cases decided at the end of then Chairman Miscamera's term in December of 2017. The case overturned BFI, Browning Ferris, which was at the time a decision at the D.C. Circuit. The decision was controversial, both because it overturned the joint employer standard, but also because the case was a wholesale incorporation of the BFI dissent into the Highbrand majority decision. And then some had argued, certainly the dissenters in Highbrand argued that the case was really a single employer case and that it should have been decided that way as it had been argued below. Once the decision issued, our Inspector General at the NLRB, in really a truly unprecedented action, issued a report finding that because of the similarities between the two decisions, the majority's decision in Highbrand and the dissent in BFI, that the two cases should be considered one for recusal purposes. And because member Bill Emanuel had been recused from the BFI case, his decision and participation in the Highbrand case was a violation of his ethics recusal obligations. So let me stop there just to talk quickly about this IG report, because I think it's remarkable and it's something that we need to address. First, as presidential appointees, we have a very specific recusal obligation. It's set out in the statute, and we have an ethics pledge that we sign with the administration. I am, and Bill Emanuel was at the time, continues to be bound by this. I cannot sit on a case where Morgan Lewis is participating in that case for 2 years. And I cannot participate in a case where I have actually done services for a client prior 2 years for 2 years. Those are the rules. And Member Emanuel had worked at Littler Mendelsohn, and Littler Mendelsohn had represented one of the parties in the BFI matter. So he was recused from that case. He was not recused from the BFI matter. So when the Highbrand,
He wasn't recused from Highbrand.
oh, I'm sorry, he was not recused from Highbrand. Thank you. So as Chairman Miscamera's term was winding up, there was an effort to get a number of cases out, which is very common. We're working on Member Pierce's end-of-term cases right now. There's a history. Former board members will tell you there's a history of getting cases out at the end of a board member's term. So that Highbrand was one of them, and they were working hard to get that out. And there was the dissent, the fact that you have a dissent in a prior case that's incorporated into a majority decision in a subsequent case is not all that unusual either. Nevertheless, our IG reviewed the deliberative process of the board members. He reviewed the email exchanges and other communications between the board members. And based on the deliberative process and based on the similarities in the decision, he decided that the Highbrand case had become the BFI case. Our ethics officer had not weighed in on this yet, and had actually indicated initially that Member Emanuel was able to participate in the Highbrand case because he was not recused, but she ultimately adopted the IG's determination and concluded that Member Emanuel should have been recused from the original Highbrand decision, and that his participation was a violation of his ethics requirements. This is he's already decided the case, she's deciding this after the fact. So to correct that, what was deemed to be an ethical violation, the remaining 3 board members at the time vacated the Highbrand decision, which of course then returned the standard for joint employer to the BFI standard. A number of motion for reconsideration was filed. There were serious allegations made by all parties. Allegations that Member Emanuel had violated his ethics obligation. There was allegations that somebody had set this up so that you could overturn the BFI, overturn Highbrand, so that the joint employer standard would return to the BFI standard. And there's a number of people very concerned about the whole ethical recusal issues at the board, because most board members, prior board members have said, have indicated that it's very unusual, perhaps even unprecedented, for an agency ethics officer to disqualify a member from a case. Typically, the ethics officer will advise. This is, of course, outside of the 2-year issue. That's black letter law. You got to be accused there. But where there's an appearance of impropriety, there's never been a case where a member has been disqualified by the ethics officer. And it's been reported in the press, Member Emanuel actually heard about the Highbrand vacating decision through the press, and he didn't even hear from within the board itself. So you can imagine he was pretty happy about that. So that's when I started. And I have to say, before I got to the board, I will admit I was skeptical of this recusal decision by the ethics officer and the IG, and I was curious about why the board had so quickly vacated the Highbrand decision. It didn't seem to make sense to me but once I arrived, and what is now public, was that the ethics officer's position was that she had the authority, based on this novel recusal theory, that she had the authority to do this, and that if any of the other board members attempted to have Member Emanuel be part of the decision, that they would be, and I would be now, violating my ethics obligations. So, as I like to say, I'm not the smartest guy, but I figured out pretty quickly that no matter how we felt about the ethics officer's decision or about the ethics officer's authority, there was not going to be a whole lot we're going to do to change it, and we certainly were going to change it within the high brand decision. And then even if we could somehow do that, we were going to be litigating the case for years, not on labor issues, but on ethical and recusal issues. So since I've been at the board, we've done several things. First, and some of this is relatively new, just this week. On Wednesday, we decided the high brand motion for reconsideration. It's been reported, and we upheld the vacating that award and the joint employer ruling. We also decided the high brand case on the merits and decided as a single employer case, not as a joint employer case. To address the recusal and ethics issues, and they're very serious issues that need to be looked at by the board, we are initiating a comprehensive internal ethics and recusal review to make sure we have at the board rules and regulations, guidelines on how we deal with recusal and ethical issues. I never want to be in a position where we have an active case where parties are waiting for a decision and we're fighting over ethics and recusal issues. So we're going to, outside of an active case, all 5 board members are going to sit down and make sure we understand kind of what the rules of the road are with respect to ethics and recusals, and to make sure that no board member is improperly excluded and that every board member who needs to be recused is recused. And then, as previously announced, we as a board are going to undertake rulemaking with respect to the joint employer standard. Some people who have always supported rulemaking now are a little bit against it. I'll talk a little bit about that in a bit. The other couple things that were brewing while I got to the board, one was the budget issue. There was, just before I started, there had been a lot of controversy about the NLRB's budget numbers. And just before I started, the Congress passed the bipartisan budget deal, which kept the NLRB's budget at the previous funding levels. So I thought that I was going to start without any budget issues, but that was not the case. Literally my first day, I was summoned to an emergency meeting at the agency to talk about the need to consider rescission. I didn't know anything about the word rescission or what a rescission was, but rescission is when the administration wants to not spend all of the money that was allocated or appropriated. And so we were asked to consider what we would have to do if we were part of the rescission. So you can see on my first day I was uniquely qualified to make those decisions. But we have had no action on any rescission at this point, and at least for now we are planning to operate on our full appropriated budget, at least to the end of this fiscal year, although budgeting, I'm learning, is quite a process, and so we'll see what happens in the future. The other issue is that was brewing, and there was a lot of press about this. I got a lot of questions about this during my confirmation hearing, was the reorganization discussions with respect to the regions. There was a lot of and this is I think General Counsel Rob, for those of you who were here yesterday, spoke about this. This is his review of the regional structure and the staffing at our regional offices. From my perspective, the General Counsel has received some undeserved criticism for considering this reorganization. Given our budget situation, the pressures there, the current staffing throughout the regions, it really is something that needs to be done. I think it's irresponsible not to look at the organization and the staffing levels. The agency's budget has been flat, as I mentioned, for the last 5 years. And as most of you know, where you have a flat budget, that actually means the budget's going down because your costs continue to escalate. In our agency, the budget is largely personnel. So as we face budget issues, we're dealing with that through attrition and not backfilling. So that leaves, and this is what I'm finding, I'm learning this just as I've gotten there, what that leaves us with is a lot of unfilled positions and understaffing in places where we might need people, and overstaffing in places where we might not need as many. Relatedly, the volume of the overall work is down, although that varies from region to region. And in some regions, they're handling a significant caseload, where in others, the caseload is down significantly. And then because of this attrition, we have, and some of the kind of stops and starts of hiring over the last few years, the mix of personnel in the regions is not match the workload. Some of the regions, for example, are significantly overstaffed in supervisors, but not enough professionals. While in other regions, they have too many, for example, administrative professionals. So it's a hodgepodge. So as we look forward, the budget's not going to get any easier, and so we really need to take a hard look at this. So, and that's what General Counsel Rob has been doing. Let me tell you a couple things I can tell you about the reorganization process. First, the board has been and will be very involved in any reorganization plans, in addition to our kind of authority to approve certain things. General Counsel Rob has been working with us, working with me very closely and very cooperatively since I've started. No decisions have been made yet. We're still working on what may happen, and like I said, General Counsel Rob's been working with us on that. Second, this reorganization effort has been portrayed in the press and as an effort to dismantle and disassemble kind of the agency and undermine its ability to carry out its mission. I want to reiterate that is not the case. It's not true. General Counsel Rob and I and the other board members have been practicing before the NLRB for years. There's a great deal of respect for the agency, for the people, for the regions, and we're really looking to make the agency better, not to dismantle it. And I was here on Wednesday. I visited Region 2 and Region 29, and I talked to the folks there and said this, and I know a number of you are here today. I know change is hard, and waiting for information is harder. It creates uncertainty and anxiety. We know this, and that's one of the reasons we're working really hard to try to get some kind of decision and announcement out as quickly as we can. So, that was my little slice of Yugoslavia when I started. I had a little high brand, a little budget, and a little regional reorganization controversy. I'm happy to say we seem to be normalizing a little bit, and hopefully things will get moving forward. Just get a little more. I'd like to talk a little bit, if I could, about my vision for the board. And I just want to say a quick disclaimer. Makes my ethics people happy, and that's what I want to make sure I do. The board is an independent agency, I sit as a neutral and decide matters as they come before me. So anything I say today is not to be viewed as indicative of how I would vote on any case or how I would decide any case or any matter that comes before me. So, with that disclaimer. In terms of my vision for the board, I will say this. I was interested in starting and being nominated by President Trump for this position because of the president's message that government at all levels needs to work to remove barriers to the creation of economic opportunities and to the creation and growth of jobs. I'm not going to say the word jobs 3 times because that seems to get people really agitated. So I'll just say it once, jobs, that's okay. In recent years, there has been, I think, and from my perspective and my practice, I think there has been regulations and restrictions, including in some of the board decisions, on businesses without a true assessment of the impact on jobs and on job creation and on how those restrictions might affect economic growth. In some cases, I think we can actually say that we may have protected some workers effectively right out of their jobs. And based on my experience and without a strong job market, many of the basic rights and protections guaranteed by the NLRA, including some of the new ones that in recent years, become really, in practical reality, an empty promise. It's great that we can protect you from class action waivers. Great we can make sure your facially neutral handbook policies and procedures are not a violation of Section 7. But if the businesses aren't creating jobs, or worse, they're reducing jobs, or if you don't have a job, class action waivers, handbooks aren't worth much, no matter how well-intentioned that was. Now, I said this the other night, it might sound like I'm siding with employers and big business. I'm not. I'm simply saying that we need to have a careful balance between the competing interests of labor and management, which is, of course, what we're supposed to do on the NLRB. But as we do it, we have to be sure that we are taking into account the importance of business interests and the creation of jobs. Now, let me make it clear what I'm saying, and more importantly, maybe what I'm not saying, because sometimes people hear what they want to hear and report what they want to report. I am not saying that the Obama board protected workers too much, or that we should in any way reduce protection for workers. That's not what I'm saying. The NLRB is here to protect workers. That's what the statute requires, and that's what we're going to do. I'm also not saying that every NLRB decision should be viewed against a litmus test of whether it creates jobs, or saying that decisions will be based on the number of jobs that will be created. And I'm not suggesting in any way that the board should undertake some kind of analysis, economic impact analysis regarding jobs. The board is prohibited by statute, although we had a little debate about this, from hiring economists to engage in economic analysis. What I'm saying, to be clear, is that we need to restore some balance at the NLRB. I'm saying that without that balance, without consideration of both labor and management interests, there is a risk that the board creates rules and regulations that impact job creation and growth. So let me talk a little bit about where I think the NLRB can play a role here. First, I think the board can play a role in job creation and growth by reducing unnecessary impediments in the form of unnecessary rules and regulations that make it more difficult to start, to buy, and to own and operate a business. From my personal experience as a management labor lawyer, I have seen firsthand that unnecessary rules and regulations are simply job killers. When hiring employees costs more, when it increases risks to employers or imposes additional operational restrictions, businesses just don't hire, and they don't invest in and they don't grow. At least they don't do it in the United States. The second way that NLRB, I think, can help with job creation and promoting economic opportunity is by focusing on more clarity and predictability in our labor laws. Our labor laws are so complex, so unwieldy, and unclear that it's difficult for employers and unions and everybody else who is trying to comply with the law to meet their obligations. And that's not saying anything about the uncertainty of our flip-flopping every 4 or 8 years as the political winds change. So whether or not we like it or not, business people who are creating jobs would tell you that they are reluctant or will not do it at all, that will not create jobs and add to their payroll and take chances that they are going to be impacted by another regulation or risk. I also think in terms of clarity and predictability, it just should not require reading dozens of cases, hundreds of pages, footnotes upon footnotes, exceptions upon exceptions, in order to dissect the nuances of our labor laws for employers and unions to comply with the law. That's one of the reasons I'm a big fan, as you may have read, of rulemaking. And I will say that I am a big proponent of rulemaking, and particularly in the joint employer issue, because I think it's the perfect issue for us to engage in rulemaking. Why am I a fan of rulemaking? Because, like many of you, as I mentioned, I started my career in a big law firm in the library, reading cases upon cases. And I know I'm dating myself, but I actually used to look in those blue indices and read those volumes and make copies of all those cases. And when we had a client that would ask, a client that was trying to comply with the law, ask us, can I do this under the National Labor Relations Act? It took a long time to come up with the answer, maybe. And that's not a satisfying answer for anybody, but certainly not somebody who wants to is deciding whether or not to put additional capital or into their business. And that's not even, like I said before, that's not even before we say to them, and this maybe is conditioned on the fact that it probably will change in 4 or 6 years. And when it does, it's going to be done retroactively. So in my view, rulemaking really provides the board an opportunity to rationalize its precedent. It's probably the reason why most other federal agencies engage in rulemaking. It's fairer. It provides the opportunity for everyone to participate and to provide their comments. It allows the board to more comprehensively and coherently address matters in a way that permit all stakeholders to understand the rules, particularly on difficult and factually dependent issues like the joint employer standard. And to change a rule, there has to be a rational rulemaking process undertaken, once again, where a new rule is gets comment, there's a notice of the new rule and comment, and prospective effective date, where all parties prepare and adjust their conduct before the effective date. Despite these very compelling arguments, if I say so myself, I've got many more, there are some criticisms of rulemaking. and particularly, there's some bias in the employer community against rulemaking. Some of it may be because it's on topics where there's been rulemaking, we don't like the substance of the rulemaking, but nevertheless, there has been some political headwinds on the whole rulemaking concept. Some talk about the fact that the process takes too long, and sometimes you have to have public hearings. You have to fully consider all of the comments that you receive. There's legal challenges. But, you know, as for all those various negatives, I think there's probably a positive on all of them. Because I think it takes this long to try to change the law or the rules in a case. And I think it's much fairer to do it through the rulemaking process. So I think that's another way that the board can rationalize its approach with respect to its case precedent. Okay. Let's say 7 minutes?
Yes.
Okay. I promise I'm winding down. Two other things I wanted to mention in terms of what the board can do, in my view, in terms of job growth and economic expansion. One, the two others I mentioned. The third is really improving the board case response time, and that really means deciding and resolving cases faster. We all know that the economy moves at a breakneck speed now, and there's just no way business can compete in an environment where they have to wait for years, 5, 8, sometimes 10 or more years to get a resolution to their case. So we have to find ways to resolve labor management disputes quicker, and where they can't be resolved, the cases need to be decided faster, and that really will facilitate our charge to create workplace stability. And the final thing I would say is the fourth and final way that the NLRB can play a role in the job creation is to avoid at all costs picking sides when it comes to unionism. The board needs to be absolutely neutral in protecting equally all under the statute, which includes the right to organize or the right not to organize. It's not for the board to decide that a union or employer should have a leg up in that process. What's that?
It's not for the board to decide.
Yeah, I'm sorry. Yeah, it's not for the board to decide whether a union or employer should have a leg up in organizing. Those who want to organize, who want a union or need a union, the NLRB is here to ensure that you have the right to organize and it's done fairly. And I think that's
Good.
so those are my thoughts on kind of where I would like to see the board go. I will say I conclude by saying that I am one of 5 board members, and so we obviously have to work together as we move forward on these issues. But that's where I see the board. So.
Thank you, Mr. Chairman. Can I ask you a question before I turn it to the group?
Sure.
While the rulemaking on joint employer is proceeding, will the general counsel still be issuing complaints in cases involving the joint employer issues?
We have,
Will they be frozen? What's?
yeah, we have not specifically addressed that, and so I guess the answer is yes. We have not made any direction on that. It's something we need to. I think it's something we need to look at.
We have time for a few questions. Any questions or comments? Would you take the mic from Tori, who was right behind you, and identify yourself, please?
Good morning, Chairman Ring. My name is Noor Alam. I work at the Brooklyn Regional Office. It's good to see you again.
Good to see you.
So a lot of the discussion that takes place in this conference is about laws that go up to the board, obviously, and go before you, and that have kind of been shifting through administration. But we're talking about a pretty old law. And a lot of the stuff we do at the regional level is actually not very complicated. We get cases before us all the time that are kind of cut and dry, where somebody's in violation of the act, and we settle it right here and there. You don't get to see it. It's done.
Thank you for that, by the way.
So going back earlier to your comment about the 5 years of flat funding and 20% attrition and the budget concerns, we keep hearing this. But a lot of the work, when we have holes in the regional level, a lot of the work doesn't get done. And it's a little frustrating to have the budget be an issue that is constantly raised to stop us from filling the gaps and enforcing the act. And honestly, the concerns about job creation and the effect that the agency has, it is a little bit of a concern that the implication is that we should be enforcing the act less, and is that really our role as an agency vested with the power to enforce a law that was passed by Congress, to really be considering the policy implications without any data about job creation or job growth?
Yeah. So, I mean, a couple of things on that. First, I would say you have an advocate in General Counsel Rob in terms of the need to put more resources in the regions because of the work you do, and that maybe the board should equally have cuts so that more work is done in the regions, so that it's not penny wise, pound foolish, where these cases end up coming to the board. So he's been hounding me about that. I do want to say, I am not suggesting in any way that we enforce the statute less, or the protections less. That is critical to what we do. What I'm talking about, and it's interesting you mentioned what I'm finding just again, only been there 2 months, but what I'm finding is that the cases that come before us, so much of what is described, what you described is true. 85% of the cases are pretty cut and dry. Employer is stupid and makes a dumb move, or this, and I've spent most of my time thinking about the 15% issues where the policy changes are important, but a lot of it is the run-of-the-mill cases. But on those 15% of the issues that I've been thinking about, those issues we need to just be careful as we look at them, and these are the ones that are the ones that change with different political winds. We just need to be careful that we ensure that there's a balance when we look at them between labor and management interests, and that's my only point with those.
In the rear, could you identify yourself, please?
Yes, good morning. My name is Frank Hausch. I'm an attorney, plaintiff's employer side attorney in the Buffalo and Rochester area, Chairman Ring. Thank you very much for coming this morning. My question is a follow-up on the previous one as it relates to your concerns about job creation at the NLRB. You suggest there needs to be a balance between the rights of workers and the interests of employers with the goal of creating jobs. I note that the recent tax bill, which created billions of dollars in wealth for corporations, was justified in the same way by suggesting it would result in a reinvestment in U.S. jobs. Instead, corporations merely bought their own stock and made wealth inequality even more unequal without creating any jobs. Why will compromising workers' rights to create more wealth not result in the same corporate profit grab?
Well, I guess I'd have to challenge you on the fact that there hasn't been the creation of jobs. Last time I checked, I think the unemployment rate is the lowest it's been in, I think, in 20-some years. And actually the unemployment rate, I think, is in a number of categories is the lowest it's ever been. So I think there has been some job growth. And my only point in this is we need to focus on the fact that jobs should not be a dirty word here. This is not, I'm kind of surprised that jobs would even be controversial. We should all be for jobs. We should all be for good American jobs. And all we want to, I think, all I'm saying is that as we look at the board cases, let's make sure, in the board precedent, let's make sure that there's a balance between labor and management interests so that we are not hurting job growth, let alone reducing jobs. Because if we don't have jobs, there's no reason we have an NLRA.
All right. On a different topic, please. Any other questions? Yes, Larry? Please identify yourself.
Larry Nathan.
Do we have a microphone coming to you, Larry?
Hi, an attorney with the Federation of Physicians. Ever since I've come to these events that Sam organizes, there's always this question of the CNN case, which has been at the board.
Which case?
CNN.
CNN case, which has been at the board
This is-
since I was in high school.
Zach, this is your
What?
case?
What?
Is this your case, Zach?
Excuse me?
Is this Zachary Fassman's case? CNN? That, I'm sorry. No, keep going, Larry.
Oh, yeah. So I think my, my basic thrust of the question is, given the fact that people tend to do things based on self-interest, do you think it'd be a service from the board to indicate two things? One, when did the CNN case start? How long is it being processed by the board? And what is your best guess as to the management fees that the case has generated for whoever the law firm is that handles the CNN case? Because I think it's been going on for a very, very, very
Okay.
long time.
Do you have
and-
information on the CNN case?
Yeah, and
John?
well, I will say this. I can't talk about active cases. I can't talk about active cases, specifics, but I can, let me tell you what I can tell you. I can tell you, yep, I do. And in fact, I was with the Brooklyn region, and I was talking to folks there that actually participated in investigating that case, and I think, you know, they were 12 when it started. I mean, so it is, we were using it as an example of exactly what I was talking about, where the board sits on cases way too long. I'm stepping into some cases right now at the board, filling in that were left from Chairman Miscamara, where the allegations or the situations that were challenged are 5 and 6 years old. I mean, I don't know how you create labor management stability when the workforce has been waiting for a decision for 6, or in CNN's case, it's been over 10 years. 10 years. And I will say, I mean, part of it, that includes a trip to the DC Circuit, and it is now in a mediation. They're trying to mediate some kind of a settlement. But it is an example of case, you know, where the issue of the board not resolving these cases quicker.
It's the issue of,
Larry.
I'm not a management attorney, but if I was, and I was working for a large law firm, a different one, and my billing hours related to keeping the case going, don't I have a vested interest in keeping the case going?
I've heard that argument before.
I'm going to step in as a moderator. I don't think John here is to talk about billing fees for various firms, and, you know, Larry. We're going to take one more. Evan, and that's it. Do you have a...
Evan Spellfogel. Chairman Ring, do you have a short list of cases or issues other than the joint single employer in which the board would consider rulemaking?
Good question.
Here's a good question.
Other cases.
Yeah, you know, I want to be careful not to specifically mention any, because we need to be careful with that. But I will say that I am open to really thinking about it in a number of areas. I mentioned to some folks earlier this week, you know, a lot of us grew up on the developing labor law, and that's kind of our first place where we go to find out what the board law is, at least in the supplement. You know, to me, that's what our rulemaking might kind of look like. Maybe we might take some areas where there's a whole chunk on a specific topic and say, codify the developing labor law in this area. I mean, now it's oversimplifying it, obviously, but that's what I think we need to do in some cases is be able to say this is the board's position, the board's standard in this area, where everyone can go read it and understand what the rules are. Because, you know, like I said, it's very difficult to, if you want to comply with the law, to be able to do so. So, I didn't answer your question, I know that. But I have to be careful not to kind of.
It's going to wait further conversations with his
Yes,
colleagues.
but I'm open to, and I will say, I think the other members of the board are open to rulemaking as well.
Please join me in thanking Chairman Ring.